Good afternoon, and thank you for joining us today. I would like to welcome you to FortneyScott's 2022 Workplace Agenda webinar series. I would like to address some preliminary items before we start today's briefing. Currently, all listeners' phones are muted. At any point in time during the presentation, please feel free to submit a question in the GoToWebinar question box. We will try to answer all questions. Today's topic is the wage and hour agenda is front and center. Our presenters are FortneyScott attorneys David Fortney, Liz Bradley, and John Clifford. I will now turn the program over to today's moderator, David Fortney.
Valerie, thanks so much, and welcome everyone to another part of our series on the 2022 Workplace Agenda. And gosh, nothing could be more on the forefront of most employers' minds and what the heck is going on with wage and hour developments in the Biden administration. So we have two of our subject matter experts that are going to help unpack those developments for us today. And I'm really pleased to be with first Liz Bradley. Liz, good afternoon.
Hello, welcome everybody.
Great to see you, and also John Clifford.
Hello, everyone. Good afternoon.
John and Liz, both great to have both of you on. All right, well, let me just say a couple preliminaries and then we'll jump right into it. Just a word I think most of you do know, and we have the privilege of counseling and advising many of you on this call, but our firm, we're based in DC. We do focus on the federal agencies that govern the workplace, including those at the U.S. Department of Labor, and particularly the Wage and Hour Division, which we're going to be focusing on today. In addition to those matters, we also do a significant amount of work on international matters, as well as a whole range of workplace issues covering health and safety, OFCCP, federal contractor, EEO, non-discrimination, and of course wage hour, as well as DE&I matters, and a number of investigations. So we against that broad context, we really want to dive in today to look at some of these key wage and hour developments. So Valerie, let's look quickly at the agenda. So first, we're going to talk about the political appointees, and we always think it's worth spending a few minutes on that because personnel is policy, and some of the key folks in the new Biden administration are here. Some are still, as they say, on deck. We'll see if they get called onto the playing field. We'll talk about that. Then we want to move right into the Wage and Hour Division, which, as I think everyone knows, is the Labor Department agency. It's called a division, but it's an agency within the Labor Department that enforces the Fair Labor Standards Act, as well as other statutes involving wage and hour rules. So we want to talk about the latest in terms of their guidance and opinion letters, because there have been a number of changes there. And finally, we want to really delve into the rulemaking. Rulemaking is going to be a critical component of the Biden Labor Department, and particularly the Wage and Hour Division. That's where a lot of the action is occurring. They've been a little slow getting out of the blocks, but as I think we're going to learn, if you don't know already, they're making up for lost time, it appears, on that. So let's dive right in, and let's talk a little bit about the political appointees. Who wants to kick off on that for us?
Sure, I think so. Going on to the next slide, we have the key political appointees. And we're going to start with Marty Walsh, who is the DOL Secretary of Labor. And
Liz, I'm sorry, I want to go back to the slide for just a moment.
Sure.
I'd like to make a point on this, that this tweet from President Biden, I'm proud to call myself a union president because organized unions know how to get it done. And we are going to ensure that we build a better America for those who build this country, the middle class. That does not need to be scripted for this president by his staff. Joe Biden has been saying that when he was the senator from Delaware, when he was the vice president, and now he says it as the president. He is the strongest, most pro-union president since FDR. And I think that driving that, I mean, here's a meeting in the Oval Office, and we see Walsh, Secretary Walsh and the vice president with the president. But this isn't sort of a staff initiative, is the point here. This is from the top of the house, the president himself, all the way down. He put together his team, and they are a deep believer in union and union policy. So sorry, Liz, let's jump
Oh,
into
no,
who else is on his team.
and this text or tweet, excuse me, is a thread that we're going to see as a number of topics that we talk about today, from the appointments to some of the initiatives to some of the executive orders. You're going to see a very strong emphasis on unionization of the workforce and getting unionized initiatives into place, into broadly into the workforce. So back to the key political appointees. And the first one we're going to discuss is, on the next slide, is Marty Walsh, the DOL Secretary of Labor. Coming up, he's been in place almost a year now. He was confirmed in March of 2021. He was the mayor of Boston for 7 years. And one of the key things to know about him, and to see again the first brick in that pathway towards a focus on unionization in the workforce, is Marty Walsh was the head of the Building and Construction Trades Council. He is the first union leader to be the head of the Department of Labor in 45 years. So to what David mentioned previously, this is all in, and pushing towards unionization within our employment broadly across all workforces.
Liz, I just was struck. Secretary Walsh, most secretaries kind of make at least some appearance of appearing neutral in case they have to resolve a dispute, a labor dispute, as they sometimes get called upon. Secretary Walsh, when the Kellogg workers were striking within the last 6 months, when he went to visit the picket line, it wasn't as an observer. He joined the pickets. He expressly said, yes, that Secretary Walsh and the president have intervened in the Amazon pending elections. Unions should be voted. So he doesn't pretend to be neutral. It's kind of interesting. He's proffered his services in the pending Major League Baseball lockout. I doubt if the owners are going to welcome that with open arms, but we'll see.
Not a neutral mediator.
Yeah, and that does have to be mutually accepted. So maybe there are limits on his bully pulpit there. I don't know.
So, and moving on to this next slide here, not listed among the appointees, you'll see, was a wage hour administrator. And one of the reasons for that is that President Biden's nominee is David Weil, who served in that same post during the Obama administration. He was nominated in 2021, soon after Biden took office. He did not make it out of committee last year. He was renominated in 2022, and he only made it out of committee by 1 vote, and only because Senator Paul wasn't at committee that day, was not there to vote. It had been tied prior to that. So he will be going before the full Senate, although we expect it to be a close call, likely that the Democrats can't lose anyone in that vote. But he is, as you may guess from those having such a tough time getting out of committee, he is a controversial nominee. In his time during the Obama administration, he was, you can say, not viewed as friendly towards the employers, extremely employee friendly, and he had a key role in many of the issues that we're going to discuss today that are hot button issues, ranging from independent contractors, joint employment, all the way to overtime rules. So, we look, if he is confirmed, we look for him to have a quick and large impact on what's going to happen.
You're going to talk about Deputy Administrator Lumen just for a moment, because yeah.
Yeah, and I did want to make one note on her. This is another union-friendly voice in the Labor Department. She was a former Minnesota construction union official, in fact, but important to note, as she's been acting wage and hour administrator, they have not necessarily skipped a beat. They have been pushing forward on the administration's goals, and that's what you'll see during this discussion today, is there's been a lot of movement in those directions, and we don't expect there, if and when David Weil is confirmed, to be lag time in getting up to speed. They are primed to move on many of these issues.
I agree with that. Yeah. So who else do we have over there at the Marty Walsh DOL?
Well, okay, so Julie Su, Deputy Secretary of Labor. She was confirmed in July. She's a former California Labor Secretary. She comes from a very liberal state, as we are all familiar with the California laws and the impact that they have on employers. She's also known for prioritizing the vulnerable employees. So the sort of a focus that she is going to bring into the administration. She's been a little bit quieter. I don't think she's quite as vocal and out there as some of the other members of the administration, but we do expect to have her have an impact on some of the initiatives and within the department. The other is Seema Nada, is the Secretary of Labor. She's actually been very active engaging with the employer community, presenting and speaking about what the Department of Labor's goals and focuses are going to be. Her background also is pretty interesting to look at and think about what she's bringing into this role. Prior to becoming solicitor, she had various roles within the Department of Labor under the Obama administration. Prior to that, she led what is now the Office of Immigrant and Employee Rights at Justice. But what's really interesting is right before that, she was at the National Labor Relations Board. So are we seeing that theme, right? Yet another person in a leadership role within the Department of Labor that has a strong tie back to, unionization of employees and those types of employee protections. So I think we're interesting to see what's going to come out of this administration.
Right. I also think that Seema particularly is a very strong asset for this Labor Department. She's an excellent lawyer. She's put a group of advisors around her who are excellent lawyers. She's thoughtful, she's careful, and precise. So I think, and I don't think that she's necessarily a rollover for her staff. So I think very highly, particularly of Seema Nanda, and employers out there under appropriate circumstances, if necessary. She is someone who at least will listen to us. She may not always agree with us, but she will give us a fair opportunity to present, and that's worth noting, and I think is appreciated. But she, it's interesting, they use Seema quite a bit on the OSHA matters to push her out. She was really designated as the front person to help explain what they were doing with the OSHA regulations, and I think that we will see similar roles for her leading the DOL as the chief explainer as they move through wage hour. And so, speaking of moving through wage hour, let's start unpacking. So we've got, those are the people. Personnel is policy. Well, let's now sort of delve into a little bit. We've talked about the personnel. Let's spend the time understanding what are the policy changes. I think everyone anticipated that there would be these, pretty significant policy changes, and I think we're beginning to see those. So, John, do you want to lead that off? Opinion letters, one of my personal favorites. What's happened?
Sure. Well, depending on your view of it, not much has happened. As you can see here on the screen, the Biden administration has ceased issuing opinion letters. I do just want to give a little context behind that, because during the Trump administration, Wage and Hour issued, in fact, 55, I believe, new opinion letters during that time. 13 of them came in that lame duck period after the election. So just a note here, while the Biden administration has ceased issuing opinion letters, what they have been spending time doing is rolling back some of those opinion letters that were issued during the Trump administration, identifying several that were not in line with what they will want to put in place, what they believe were appropriate interpretations. In fact, that began immediately after President Biden's inauguration the following week. They identified several opinion letters that rolled out at the end of the Trump administration, providing guidance on rules regarding tip pooling, independent contractors, both subjects we'll touch on later, for rules that had not yet become effective. They rescinded those on the grounds that they were premature, as the rules weren't in place yet, and they weren't in line, again, with what we expect to see from this administration and from the agency on those topics. In February, they identified more opinion letters that they thought took too much of an employer-friendly stance on some of those same issues. Again, independent contractors continues to be a focus point on these, identifying these opinion letters that had really changed the way things were viewed in regard to who was an independent contractor and who was an employee. David, I know you had some thoughts on the importance within wage and hour of the opinion letters.
So, we've said that they ceased, and certainly the record to date is they have not yet issued. Interestingly, I don't think they've officially turned it off. And if
Right.
The solicitor Nanda were here, I think she would say, well, I didn't say we stopped. And my rejoinder would be, but after 12, 14 months, you're not issuing any. And all you've done is torn up ones that were issued. So that feels to me like they've ceased, but in theory, they still could. These are important, though, for employers and I would say for unions, for all stakeholders, because it enables the regulated public to have certainty that is reliable, that you can, if you will, take to the bank. And by take to the bank, under the Portal Act, here's the technical explanation, legal explanation. Under the Portal Act, you can raise as a good faith defense your reliance on a published opinion by the wage and hour administrator. That's what these opinion letters constitute, which means that even if the court disagrees and finds that the conduct was violative of the Fair Labor Standards Act, it enables you as a defendant to avoid liquidated damages or willful violations. So it helps in terms of exposure, and it also, I would suggest, particularly with limited resources of the department, helps leverage and promote compliance. That is what they're about. I think they've gotten a bit of a bad rap. I recognize which way the tide is running. It's against them, but I think that's unfortunate, and I'm hoping that perhaps, of course, maybe we wouldn't like what the opinion letters are, so maybe no opinion letters better than one we might get from the current deputy administrator. But in any event, opinion letters are important. They historically have been part of the toolkit that this agency uses to promote compliance. So I think it's important. But how about other forms of guidance?
Sorry, I muted myself for a moment. So other guidance, the liquidated damages are back. So in April, Field Assistant Bulletin number 2021-2 rescinded the Trump era enforcement policies of not imposing liquidated damages in pre-litigation investigations and settlements, which is a way to sort of benefited employers that they could resolve these matters without triggering the obligations for the liquidated damages. That policy is gone. This is going to impact employers, and I think it's some of that benefit, that weighing of, do you enter into pre-litigation settlement? A reason to do so is to avoid those liquidated damages. If those are back on the table and you have a legal argument that you're not actually in violation, I think it's going to discourage employers from wanting to enter into any pre-litigation resolutions. So those are back. In addition, the Department of Labor is reducing. I don't know if they've totally admitted that they're stopping using the WH-58 letters. They're more using them less. But the key part of that is those forms included a release. When you were making a back pay payment under a settlement with Wage and Hour Division, it included a notice of payment and a release of the FLSA claims by those individuals who are receiving payment. They're not using those as much. So that is also another factor for employers to be considered. They used to be thinking, well, at least we can get this resolved pre-litigation, we get resolved from any potential claims, we can pay this, we can move on with our practices. So not really sure what's going to go on there. I know there are some employers who have sort of used their own version of a WH-58 and trying to get around that. Not sure how enforceable those ultimately may be. There's some potential challenges that could be on the table for that. Fact sheet 84, the COVID compensable time. This is a fun little one. So I know we were all talking about, as COVID was coming out, requirements to test, etc. What's compensable time? What needs to be included? What employees need to be paid for? Then is that part of their overtime rate? There's a lot of questions about that needed to be answered with regard to, is this compensable time under the FLSA? For a brief snippet of time, a few hours, the fact sheet 84 was published, and it actually held that yes, this is compensable time for employees do need to be paid for this, and it gave and it sort of reflected the current DOL's views that outside work activities related to COVID-19 are considered compensable because they are integral and indispensable to the employer. That opinion letter went away. It got pulled down. Solicitor has announced that they have officially rescinded that and pulled it down. We don't know how it got up, why it was pulled down. We have a copy of it. I still think it's something that can be referenced because it does show where this DOL would likely come down on that issue.
I think there are a couple things on that. I mean, it was characterized as having been issued inadvertently, and employers were advised they should not, quote, rely on it. So you're right, for a couple hours, it did represent the department's view. And it did recognize that not all activities were compensable. For example, on the vaccine versus testing, if you go back to the OSHA standard, which did not mandate vaccine testing, vaccines, but it allowed either vax or testing. For those employees that voluntarily opted for testing, that were eligible to be vaccinated, but that opted not to, it did allow the employer to say, fine, if you want testing, you could be vaccinated, you'd be paid for the time to be vaccinated, you'd be paid for the ill effects afterwards if you suffered any. But if you opt to be subject to the weekly testing, that would not be compensable. And that part was pro-employer. I think that's what actually caused some in the department. It's the first obvious misfire that the Biden wage hour departments had. But I think that caused heartburn because that was in conflict with published guidance that wage hour had pending on its website. They made a distinction for those employees that had to be tested for an accommodation, either for religion or disability. In other words, they could not be vaccinated, then that testing time would be compensable. But these other issues, so it had some pro-employer parts, which the cynics would say that's why they tore it down within less than 24 hours. But I do think it represents, honestly, the correct reading of the law, keeping in mind what's compensable, whether you suffer or permit. That wasn't for the benefit of the employer. Employees that said, I just opt voluntarily not to be vaxxed, I'm going to be tested. That's to benefit the employee. That was the rationale there. And I think it was, it's useful. And I think even though it's been rejected by the department, those that are litigating these issues, it's wide open and available to you. And it's roadmapped out for you in that opinion letter.
Agreed. Agreed.
Okay, anything else on those points? No?
No.
You know what, I actually do want to, I'm sorry, can we go back? I want to go back, thank you. 58, the form 58. Yeah. This, Liz, you touched on that. It used to be that we would go forward. If we found violations, we might go and voluntarily even ask the Labor Department to supervise. But these 2 points that Liz covered for us really underscore that's over. If you go to the Labor Department voluntarily, they're going to insist that you had liquidated damages, and they're going to refuse to give you the supervised release form. So what Liz underscored, I think, is the right way. And we've had clients in this new era that have started to embark on it's not risk-free, but the concept of whether, and a limited number of courts have recognized, maybe you could have a release even if it's not supervised by the Labor Department. For example, if you had a union involved and the union agreed that it was in accordance with the CBA and they were authorized to pursue it. Those are there, and there are other unique fact patterns and a very limited body of case law that have recognized this, including putting releases on the backs of checks, having people sign acknowledgments that all possible hours they work have been fully compensated at applicable minimum wage and overtime rates. et cetera. I mean, there are some tools left. We employers are not left without anything, but
Correct.
this is a blow. We don't have the guaranteed kind of standard safe harbor types that we had before. Okay, anyone have anything else on these points? All right. Well, let's go to rulemaking. And this is where I think the majority of the action is going to be by the Team Biden. So now, you know, we've got to pivot to, they've spent most of their time, it sounds like, tearing up things, but are we expecting new things in rulemaking, and what's torn up and what's there? So John, do you want to start this, please, for us?
Sure. And what this slide shows is the fall regulatory agenda that was put up, although I think it may have come on the very last day of fall, possibly, but a fall nonetheless. And we're going to cover, as we go through the rest of our presentation, many of the issues that you see here, or many of the rules that you see here that are categorized as in the final rule stage. So I won't belabor those too much at this point, as we'll address those down the line. But I did want to touch on these. At the top of the screen, you see these proposed rules. One goes to the exemptions, overtime exemptions for executive, administrative, and professional, as well as a few other employees. And the other is modernizing the Davis-Bacon and related acts regulations. With regard to the overtime pay requirements for those white-collar exemptions, the agenda, some of the additional information that was provided with the agenda did make clear that they would be looking to update the salary level requirements for these exemptions, presumably raising those. And again, just going back to one of the first slides, David Weil's involvement in this very issue during the Obama administration, he was pushing for a significantly higher salary threshold to be exempt. It was approaching 50,000, I believe, as opposed to what is now at right around 35,000. So keep your eyes peeled on what's going to be coming down the pipe on that. There could be big changes coming. And I know with regard to Davis-Bacon, this is something we've been waiting on. We understand it's imminent. I will let Liz touch on this briefly, because I know she's got this saved on her screen right here to check in on this.
Yeah, my morning ticklers, yes. So these are imminent. So we know OIRA has completed their review. That's the last step from these actually being published in the register. So we expect these to come out very, very shortly. They've kept it pretty close to the vest about what the content of the modernizing the Davis-Bacon and related acts is, the specifics of it. However, we have some insight into that based on some critiques that the Wage and Hour Division has heard with regard to Davis-Bacon. The first one, and I think this is one I'm most comfortable kind of making a crystal ball prediction on, is the outdated nature of the prevailing. There's two things. Prevailing wage rates set forth in the wage determinations, a number of them are outdated. There are wage determinations out there that still have rates based on the prevailing wages back in the 1980s. Okay, we know those are outdated. That's one piece. Another piece is the manner in which they collect that data. How do they know who's responding to those, their source of gaining prevailing wage data? So one of the predictions that we are pretty confident in making is that they are going to tie Davis-Bacon wage determinations. The prevailing wage rate is probably going to be very closely tied to, wait for it, the prevailing or the local union wage rates, right? That thread. I think they are going to be starting leveraging union wage rates in order for setting the Davis-Bacon wage determined rates. So that's something that I do anticipate. And I'm going to pivot on this for a quick second here. What was also interesting is on the 4th, President Biden, issued executive order. It's now been named 14063, which is the use of project labor agreements for federal construction projects. Okay, DBA covers federal construction projects. We now have an executive order that talks about that has a requirement for using project labor agreements for all federal construction projects that are above a $35 million threshold. Well, once we get into these infrastructure projects that are going to be governed by DBA also, but these infrastructure projects, getting to a $35 million threshold is not going to be tough for some of these large, infrastructure projects. So again, and project labor agreements, that means you are entering into an agreement with a union to govern the terms and conditions of the work for that project. And I know David has a little bit more he can share on this, but essentially it is leapfrogging and avoiding the obligation to have an election and to get your employee seeking representation. So these
Right.
are some pretty big deals. David, go ahead. Sorry.
Yeah, no, that's right. And so, as Liz has explained, Davis-Bacon, unique concern to construction for laborers and mechanics that provides prevailing wages and benefits. And then these project labor agreements, or PLAs, which effectively means that even non-union workforces that are working, and this is at not just the prime, but any tier of the contracting. So think about a major infrastructure project. Think about a road project, for example. All the different contractors working on that, from suppliers to all the different trade skills involved, et cetera. Those are all going to be under this project labor agreement. So when an employer, subcontractor comes on site and participates in that, they will be required to pay the employees as if they had a collective bargaining agreement, the rate, the collective bargaining benefits, the union dues. They'll be required to follow the collective bargaining agreement dispute resolution agreement, et cetera, the whole package, so that the concept that employees individually get to choose, do they want to have a union represent them? Do they want full membership in a union, or do they want representative status only, and only pay for core functions? All of those decisions are removed and eliminated. As a condition for working on it, the employees will be subject to all of these union terms. The practical matter is we have a number of clients in the construction world that are non-union, and they're quite successful with that business model. And they work on various projects. And yes, when they work on a federal project, it may be subject to Davis-Bacon rate, but it doesn't have all of these other union attributes associated with it. They are greatly concerned because this is a fundamental realignment of the business model. So you get a cadre of employees. They work on a big federal project for 1 to 2 years. Now that project's over. Of course, those employees are going to be more receptive, more vulnerable to union organizing. And of course, the AFL-CIO knows that too. So there are a lot of bigger concerns. I mean, the costs are much greater under PLAs, that's a given, but also the ramifications on the employers beyond the project, the four corners of the project, into the rest of their workforce and the rest of their operations. These are very significant and controversial. These are legal. They have been involved in major public projects like the Alaska Pipeline, the Boston Big Dig. 35 million, as Liz points out, is a very low threshold for the type of contracts we're talking about. So this, if you can't get the PRO Act enacted, this is about the most you can expect in terms of a Christmas gift to organized labor from the administration.
Yeah, and I do want to point out both of these. So the modernizing Davis-Bacon is coming out as a notice of proposed rulemaking. It is going to be subject to the notice and comment provisions. The executive order, FAR Council is needs to issue proposed regs by June 4th, and they could do it sooner, but it too is going to go through that notice and comment provision. Be looking at these, engage in this process, right? This is, while they're coming, you also do have a voice if we can engage in the notice and comment provision and give some feedback on some of whatever we see in those proposed regs. So that's just my little, call to action there before we.
And final note is those of you later this year bidding on and looking at these infrastructure contracts, and many of you will be, you should look for these PLA or project labor agreement provisions that are effectively guaranteed to be in place after the amendments to the FAR that Liz has just spelled out for us. Okay. John, anything else you want to cover on this slide, the agenda?
No, I think we'll touch on the remaining issues on the upcoming slide. So I think we can move right into our coverage of some of those joint employment here.
All right, the saga of the joint employment rule or test, right? So recall, Trump issued a final rule. Trump administration, there's a final rule issued in January of 2020 with regard to the joint employment rule. Was going to go into effect in March of 2020. Very employer friendly test, as we expect under the Trump administration. There were challenges to that test, and it was a New York federal district judge, sort of a case was brought by 16 attorneys generals challenging that. It got put on hold, and then the Trump DOL appealed that decision. So pause that for a minute. So then the Biden administration comes in and they rescind the Trump administration joint employer rule. That rescission went into effect in October. Okay, October 5. Magically, the very next day, October 6th, the Biden DOL then filed a motion to dismiss the Trump DOL's motion, the appeal of the decision. So there's been a lot of maneuvering back and changing through which administration is ruling, and the court ultimately did grant their motion is being dismissed. So the appeal is dismissed in October. Sort of leaves us at limbo here with what is the joint employer rule. And I think that, as we've talked about in other things, there's going to be a bit of a coordination between the NLRB and DOL with what the joint employer test is going to be. And we expect that's going to be kind of the next wave that's going to go out. And again, who's probably leading that initiative? Again, it's NLRB. So another theme that we're seeing, where that pulling that union thread through and providing a little additional voice to NLRB with regard to the FLSA classification of joint employers.
One thing that strikes me, I think many of us expected a revised rulemaking by the Labor Department, and note what's not there: a revised rulemaking by the Labor Department. So they're going to, and this is back to the comments earlier on the solicitor, this really underscores the enforcement is going to be driven based on the case law under the FLSA. There are different tests in different circuits. So employers, multi-state, multi-circuit employers, this is a problem. You will need to look at the governing standards in your circuit to ensure that your current configuration complies with it, and you don't want to run afoul and be deemed a joint employer with one of your contractors, number one. Number two, that although there are these slightly different legal standards under the National Labor Relations Act and the Fair Labor Standards Act, to Liz's point, they are going to try to harmonize those, because it is conceptually possible you could be a joint employer under the National Labor Relations Act, but not a joint employer under the FLSA, et cetera. So the administration tends to harmonize those in a very anti-employer fashion. That is, it'll be very easy to be deemed a joint employer. If you have the ability to control, it will be more akin to the California type so-called test that I know many of you are familiar with. So I think that's the direction, but in the next 12 months, there's this chaotic circuit by circuit Labor Department, and inevitably we should anticipate meaningful enforcement, judicial enforcement against some unfortunate employers, I think, under these claims. So, well, the companions often ICs, who's properly classified as a contractor versus employee. John?
Right, so the independent contractor, as you can see, we've got a number of dates here, not quite as convoluted as what Liz just went through with the joint employer, but they tried. It's close here. So this does go back to January 7th, actually, the very last days of the Trump administration. The Wage and Hour Division published a final rule putting forth a new test for independent contractor status. And that was set to go into effect on March 8th of 2021. Just a couple notes on that new rule. It would have put in place what's referred to as the economic realities test, and it would have really focused in on just a couple of the factors that are commonly considered, those being the degree of control and opportunity for profit and loss, and we won't get too much into the weeds on those, but the result of that type of test is that it would have made it much more difficult, or it would have made it easier, I should say, to be an independent contractor, or difficult to show that someone is an employee under that test. After President Biden is inaugurated, a couple weeks later, on February 5th, they delayed the implementation of that rule, and they pushed that off, and then eventually proposed a new rule and did withdraw that regulation, which had been finalized at the end of the Trump administration. That withdrawal became effective on May 6th. Again, we do not have a new rule replacing that. What we do have is the decks are cleared. There is space for a new rule to go into place. Already, just taking that rule off or withdrawing that rule opens it up to more employee-friendly interpretations, I think, of the tests that are out there. But this again is where we expect it's likely we may see some movement on the independent contractor test. This is not to keep beating this drum, but another area where David Weil is, very prominent in his opinions on the independent contractor status, and has views that he's espoused that would make it very difficult to be found an independent contractor compared to the tests that have previously been utilized.
Great.
Right, and Professor Weil, his current status is he's the professor. When he formerly was the wage hour administrator, developed and coined the term the fissured workplace. And this is when he noted that although these people purport to be contractors, they're just sort of one big workplace that employers try to fissure it or divide it up. And he has told me that he coined the term fissured from his wife, who's a geologist, and he thought that just described it perfectly for what that's worth. But in any event, the interesting thing is that the Labor Department, even though Professor Weil hasn't returned for Weil 2.0, in the guidances that they have published that we're going to talk about, they have now reintroduced the term fissured workplace to describe what they're doing. So that's point one. Point two, this also has a very strong nexus back over to the NLRB. I know we've beaten that drum, but you can sort of plug and play all the points that Liz has made for us on this about the importance. And the coordination, because if you have an individual who's misclassified as a contractor and becomes an employee, that ripples out not just for wage hour, minimum wage and overtime. It ripples out to coverage of all of the workplace rules and statutes. Title VII applies only to employees, not contractors. National Labor Relations Act, right to organize, employees, not contractors, etc. So this is an issue, and this administration they understand that point crystal clear, and they are quite well coordinated among multiple agencies in how they are approaching this. So it won't just be a chaotic snowball, but it will be snowballed up. And if they do push the ball, and they will, to move the line on reclassifying these workers as employees, it will ripple through wage hour plus all the other workplace statutes and enforcement policies. So this one affects every single employer in the United States, because almost every employer uses contractors in their operations, particularly so today with the labor market being what it is. So I personally think of all of them, this one is the big enchilada, but we'll see.
I do. I think this is probably the area of biggest risk for most large employers, is the use of the contract labor.
Yeah,
it's in there, and it's weaved into your workplace.
It's weaved in, and the staffing shortages and the exigencies caused by the pandemic, people are using contractors more than ever to just meet their basic operational needs. So there's a real tension here between the economy and the employer's legitimate interests versus what the current administration is trying to do. That will be interesting how that plays out. All right. Well,
Tip sharing. All right. We won't spend a lot of time here because I don't think that there is most of the attendees here are having the tipped employees in the workforce. One interesting thing here is this is one where the Biden wage and hour division is actually keeping some of the Trump and changing some of it. So there's a little bit of a hybrid here. But some of the key points here is that effective April 30, there is the employers, prohibit employers from keeping any portion of the tips. That is staying in, if they're using a tip credit. And they are allowing some of the non-tipped employees to be able to get a portion of the tips, such as some of the back of the house and other employees who are not traditionally tipped. They can receive a portion of those tips without destroying the tip credit. In addition, employees are entitled to receive their full regular minimum wage for that side work that they do, if that spends more than 20% of their time. So you still have that de minimis concept in there, and if it's spending, it's 20% or more, is the test. So if they spend 20% or more of their time doing the side work, then that is going to trigger the full minimum wage obligations. Below 20%, they can still be paid tipped, the tip credit off those hours. So those are sort of the main highlights on tip sharing.
Yep.
Next.
This has been one that's just always, tip sharing is always one that's so controversial and continues to be. All right.
Correct.
Well, let's hit some real bread and butter issues for so many in the audience, the minimum wage for federal contractors. We've unpacked that a little bit.
Right. We've touched on this, and I'm sure as David noted, as many in the audience are likely aware, back in April of 2021, coming up on a year ago, President Biden issued Executive Order 14026, which will increase the minimum wage for contractors to $15 per hour for federal contractors. And what they've done here is that's for covered contracts, and I will just go through the types of covered contracts here briefly, but it's any contracts covered by construction under the Davis-Bacon Act, service contracts under the SEA, the Service Contract Act, concession contracts, or any contracts in connection with federal property or relating to services for federal employees. This has gone into effect, I should say, for any contracts entered into on January 30th. But I also just want to note that any contracts entered into prior to then, this will be implemented, the higher wage will be implemented as contracts are extended or renewed. So it's going to be fully implemented into these contracts as they're going through their natural cycle here for renewals. And I believe we actually had some news we were discussing before. There's some recent news regarding litigation on this topic. David, I believe you were noting some recent litigation that was just filed.
Yeah, very. I guess knowing that we were going to have this webinar today, the attorneys general in 5 states decided yesterday would be when they would file a complaint seeking to enjoin these new regulations and the $15 minimum wage that the president imposed. And those states, and you can pull out your geopolitical map and speculate probably accurately the most likely states, but it was filed in the state of Arizona and supported by Idaho, Indiana, Nebraska, and South Carolina. Those are the 5 states whose attorneys general have said that this represents a desire to achieve social ends, and it is an illicit and impermitted action under the federal procurement statutes. It does not directly relate to efficiency. In fact, it has the opposite effect and mandates higher costs for contracts than otherwise could be procured in the marketplace today. We'll keep our eyes on that for you, but that Those sorts of arguments not authorized by the statute, that's exactly what the Supreme Court relied on to kill the ETS.
Mhm.
Second point I want to make, which is I think of why this is such a big darn deal. The in connection with, look at the scoping on this. So we know that Davis-Bacon applies to laborers and mechanics. We know that the Service Contract Act prevailing rates provide to service employees, but this in connection with, that potentially picks up the Human Resource Department, the Accounting Department, the people that work in connection with the contract, even if they're not subject to the prevailing rate, they may be subject to this super elevated federal minimum wage rate. So I would just counsel that employers that have these, that are subject to this, you need to look and understand the breadth of this. It's broader than the prevailing wage obligation and affects a lot of your workforce.
And I just want to tag on what David mentioned about the action by the 16 states, I mean, not 16 states, but the 4 states. Those arguments about not being the wages being mandating higher than what you could get in the area, those are the exact same challenges that are going to come to the DBA regulations and the labor, the project labor agreements. The percentage of unionization in certain areas is low. There are numbers that show that private unionization is at an all-time low right now. So then mandating rates for theirs across the board, that is a strong argument that's going to be said that this is not going to be, these are not the prevailing rates, and that the government is spending higher than necessary rates. I think that those arguments are going to be seen filtering across all of these initiatives that are being put forward.
Great observation, Liz, and you're exactly right. Private unionization is less than 5% in the United States of America today. It's the lowest it's ever been since the labor laws went in. And construction, although they have a much higher relative percentage rate, they're not even close to 50%. So huge numbers of employees are going to be
Hard to say
impacted
that
by this.
that's the prevailing rate when it's not the prevailing representation.
That will be the argument. And I would predict there'll be some judges that might find that to be quite appealing, but we'll see. We don't get to wear the black robe, we just report on it. So there we go. All right, any additional changes? Are they tearing up anything else?
Of course they are.
Of course.
All
Okay.
right. So the payroll audit independent determination paid program has been canceled. Under this program, employers are able to self-report wage and hour violations without the threat of litigation and additional damages. That's out, and what Jessica Lumen has stated that the paid program deprived workers of their rights and put employers that play by the rules at a disadvantage. So that program is gone. And another that's also, is this also discouraging employers from doing these self audits and making the necessary corrections when they find something wrong? So while we understand their position, that the department's position that it's not compensating employees right, I think it's also going to discourage self audits and self correction. So there's a push and pull there. I think it needs to be considered. The enforcement agenda. Okay, I think this is again a thread that we've talked about a little bit. In November, there was a joint anti-retaliation agenda announced between DOL, EEOC, and who is that? Oh, NLRB, right? We've talked about them a little bit tied to DOL today. So they are going to be looking at combating retaliation in the workforce, and they're going to collaborate with civil enforcement agencies. So this is something that thinking about, the agencies are going to start talking and start coordinating. Very similarly, in December, there was an NLRB and Wage and Hour Division Memorandum of Understanding, 5-year MOU to coordinate information sharing, coordinate on investigations. They're going to be training their investigators to look for violations on the other side of the line, so that when, for example, Wage and Hour is in there doing a compliance evaluation or audit, or et cetera, they'll be looking to see, oh wait, trigger, that might be an NLRB violation, and vice versa in Wage and Hour. So that is something to be thinking about. I know we often kind of think, these auditors are in here for this narrow purpose. This is the wage and hour group. We don't need to be worried about some of the NLRB issues. That's not the case anymore. They're going to be crossing over and looking at those issues. So I think that is, not surprising. It's all the government. The fact that they are learning this information, sharing it across agencies, not, probably a good use of resources, but expect to see
Well,
it, prepared for
I
it.
don't know if it is or not, but we'll see if it's good use of resources. One of the other things that the wage hour team will be doing is not only saying you may have a problem that the National Labor Relations Board can help you with. They have a designated form. It's the government. They have a form. Here's how you go to the National Labor Relations Board. Here's how you file an unfair labor practice charge. So they will be wage hour will be specifically educating individual workers how they can file charges with the National Labor Relations Board, because the NLRB, in contrast to wage hour, can only act in response to charges. It's a charge-driven agency. So to some extent, the critics are saying, gosh, wage hour's out there beating the weeds to find and encourage people to file charges against their employers. Maybe, but and the truth is that most of those interviews that wage hour conducts, we as management do not have the right to be present, so we won't know. But they have indicated this is part of the new standard operating protocol. So I think these are really important takeaways. So if you have a wage hour audit, you should understand what that means. That's not going to be friendly. So one other thing you mentioned about the paid program being canceled. This puts a premium on, if you are going to assess, and you should, whether your wage hour practices are compliant, please do it with counsel. At least make sure you have the attorney privileges. You can use your corporate counsel, you can use your outside counsel. We work with many of you on that, but that is a very important practice pointer. Do not overlook that, because there's going to be much more activity and interest in what those results are. All right.
Absolutely agree.
Few minutes left. Final thoughts. Mr. Clifford.
I think we've touched on some of the areas that this administration is focusing on. They've said it. They've said increased enforcement is coming. It is coming, and we can, based on what we've gone through today, you can see the areas that it's likely going to come in. So they're looking for more investigators. They're hiring. It is coming, so employers need to be prepared for that increased level of enforcement moving forward.
Liz?
Pay attention to the notice for proposed rulemaking. Get involved, notice and comment, be heard. These changes, they have to go through this process. You do have that opportunity to provide comments, issues, make sure, get involved. So call to action. Don't let these things just come out at you.
And mine would be appreciate the linkage between wage hour compliance and violations, particularly with the National Labor Relations Board. We've gone through the personnel, what their background is. We've gone through the new policies, the close coordination, the rulemakings. All of that indicates it's very intertwined. So very strong, because many of you are non-union today. You're not familiar with the National Labor Relations Board or union organizing. Get familiar. It is important and integral to what you need to be doing. Okay, well, the final thing I want to just note, we want to thank everyone for coming. We do have an excellent sum up briefing paper. And Liz and John, I want to thank you both. You really did a great job on that. And on behalf of all of our attendees, that's a real benefit. So thank you everyone for joining, and join us again for our next one on the Workplace series. All right, thanks, Valerie. And also I'd say, check out the podcast too, if I can just put a shout out, DC Insider Employer Update Podcast. Because we do every 2 weeks talk about topics just like this and a number of other topics. So Valerie, I'll turn it back to you.
We would like to thank you for joining us today. Next in our 2022 Workplace Agenda webinar series, we will be discussing the NLRB seeking aggressive pro-union agenda. This webinar will be presented on Wednesday, February 23rd at 12 noon. Be on the lookout for additional updates, which will be sent via email. Later today, you will receive a survey requesting feedback for today's presentation. You're able to submit suggestions for future topics through the survey. Thank you in advance for completing this survey, and of course, if you have any questions, You may submit them via email to info@FortneyScott.com.
Thank you.